relating to accessorial liability. For a very short definition, accessorial liability is the establishment of the liability of an accessory for the principal's contravention or offence in circumstances where that accessory intended to participate in the contravention or the offence by knowing the essential matters that make it up. Productivity Partners is an interesting case because, in our view, it confirms that an accessory does not need to know the full consequences or the character of an act making up the offence to be knowingly concerned in it for the purposes of establishing liability. Rather, the court said in a number of judgments, but that they were unanimous on this. The inquiry is directed as to what the accessory knew of those facts or circumstances or state of minds making up those essential elements. And I think that it's arguable somewhat of a lower bar than had often been contended for, particularly by defendants in the past. Such a case will be of interest, we say, to practitioners who are contemplating bringing proceedings against accessories or defending against them. My experience in this context is under the Fair Work Act, which is one of the few statutes in which individuals can bring civil penalty proceedings against defendants and have penalties paid to them. For an individual, a penalty can be as high as almost $200,000. So understanding how individuals can be made liable for the acts of principals in this context is particularly critical. I should note that these accessorial liability provisions in this case also apply across a range of other statutes in the Commonwealth and also in some places in New South Wales. I'm thinking particularly of the Work Health Safety Act. For my part, at least this evening, I'll be starting off by just giving you an overview of the facts of this case and then the principles derived within it. And then I'll move on to give an example of how I think that will now apply in the civil context, using the example of a wage underpayment under an award. And then Eric, what I think will be the most interesting part of this talk, will examine those principles. We'll examine those principles in the context of a case that is currently before the High Court, which is the King and Batak, which is an appeal by the Crown as to whether the concept of constructive murder under the Criminal Code embraces the principles of accessorial liability. If you have questions, we'll hold them to the end. But if you can put them in the chat, we'd be grateful, or otherwise email the Clerk of Level 22 Chambers, Jackie Charles. Okay, so I'll now run through the facts of the case so that you have an understanding about how the principles were then derived. Productivity Partners was a case that considered the application of the accessorial liability provisions in the Section 224 of the Australian Consumer Law to the prescription against unconscionable conduct in that Act. Productivity Partners was trading as a vocational college, which received tuition loans from a Commonwealth scheme that required the enrolment of students after the census date. And the second appellant in this matter, Mr. Wills, was the chief operating officer of the parent company of that college. On the 7th of September 2015, the college's management, which included Mr. Wills, implemented changes to student enrolment in order to meet sales and marketing objectives and combat falling revenue. And it did so in two important ways, by removing quality assurance calls that were undertaken to ensure that students understood what they were enrolling in, and also monitoring their attendance and withdrawing them before the census date if they weren't engaged. When deciding to make the change, importantly, the college knew that the controls were important safeguards against the enrolment of students who did not understand what they were committing to. And in the few months in which the changes had been implemented, revenue had been up 5,000% on the average. A couple of months later, on the 20th of November, Mr. Wills became the acting Chief Executive Officer of the college, and the full federal court found that it was on this date that Mr. Wills became aware of the full consequences of these changes, and only then had he became knowingly concerned in the college's principal contravention under the Australian consumer law. It was on appeal to the High Court, and this is across 4 substantive judgments, which Chief Justice Gageler and Justice Jago, Justice Gordon, with whom Justice Stewart agreed, Justice Edelman and Justice Beach-Jones, with whom Justice Gleeson agreed, then considered 2 issues. Firstly, whether the full court correctly found that Mr. Wills had the requisite knowledge to be accessorially liable for the college's contravention of Section 22 of the Australian Consumer Law. Notwithstanding, there was no evidence that suggested that Mr. Wills actually knew that the college's conduct in removing those important controls would result in the taking advantage of its students, or had the character that meant that it was against conscience. And the second issue was whether the full court should have found that Mr. Wills had the requisite knowledge or the requisite participation in the college's contravention as at that earlier date, and not just when he became the CEO, in circumstances where he'd had the authority to prohibit the acts but took no positive steps to further the conduct himself. In relation to the principles, the various members of the High Court made a number of observations. As to the point of principle as to what constitutes an essential fact or essential matter of an offence or contravention, Chief Justice Gageler and Justice Jago said that the essential matter of an offence or contravention were those facts or circumstances or states of mind which make it up. It was unnecessary, they said, to know how those acts might later be characterised, including by a court or its nature. Their Honours went on to use the example of the prohibition against misleading and deceptive conduct. And in that scenario, Their Honours said further that an accessory would only have to know in that case that the representation was false and the circumstances in which the representation was made, and that knowledge of the potential or actual character, quality, nature, or status of the conduct as misleading or deceptive for the purposes of the statutory prohibitions against such conduct were not required, and mere knowledge of facts from which a person might have deduced or inferred falsity was insufficient. In this way, the court, or those two judges, found it wasn't necessary for Mr. Wills to know that the changes were unconscionable for him to have knowingly participated in them. That conclusion was also reached by Justice Gordon, who in further, Her Honour endorsed the long-standing principle that it's not necessary for a person to recognise a contravention as such, or explicitly think about how the relevant legislation that their actions might contravene. Her Honour then adopted 4 essential matters that the full court in the proceedings below have identified as essential. And that was Mr. Wills' role in the college, the knowledge of the 2 risks mitigated by the system's measures that were removed by the college, involvement in and knowledge of the enrolment process changes, and knowledge of the effects of those changes. And when we say knowledge of the effects of those changes, again, we don't mean the full consequence, but the general effects. And in considering how one establishes accessorial liability, Justice Edelman went on to helpfully set out the steps involved in this task. And that is, firstly, the identification of the essence of the primary offence, the identification of the acts of the accessory, the amount, the involvement in the essence of the primary offence, and thirdly, the identification of the intention of the accessory to be involved in the essence of the primary offence, which His Honour described as often being the central issue in litigation. Intent being very important because accessory or derivative liability requires an accessory show a purposive attitude towards the acts themselves. And while the court did approach this issue in 6 separate judgments, the court unanimously held that Mr. Wills had knowledge of the college's changes to its student enrolment systems, and that was sufficient to establish accessorial liability, and that it was importantly unnecessary to prove that he knew that those changes were unconscionable under the ACL or otherwise how they would be legally characterised. Secondly, the court also found that Mr. Wills had the requisite actual knowledge as at that earlier date, before he knew of the full consequences for their students, such that he knew that the changes would improve the college's revenue. He knew that the changes were important safeguards, and absent any knowledge of the full consequences, that was sufficient to render him accessorially liable. Plainly enough, there was significant focus on the knowledge of the essential elements of the contravention, such that an accessory would be said to be knowingly concerned in the principal's contravention. I thought this was an interesting point, but it was initially, at first instance, submitted that Mr. Wills also had to have intentionally participated in the acts making up the essential elements of the contravention, as well as the requirement of knowledge. And at first instance, at 103 to 108, Justice Stewart rejected this principle following a close reading of the seminal case of York and Lucas, which is in the handout that we've provided. That was not disputed on appeal, and I think it remains to be seen whether that will be picked up and applied in other courts. I know that Justice Katzmann has done so in 2 recent decisions in relation to the Fair Work Act, and I can imagine the fruitful application of those principles for applicants in the future. To that end, having talked about the principles and the facts almost in the abstract, I'll move on to perhaps a more useful practical example of the principles in this case, using what I consider to be a fairly common claim in the employment law, which is the underpayment of wages owed under a modern award amounting to a contravention of Section 45 of the Fair Work Act. Relatively often, directors, accountants are named in these kinds of proceedings, particularly in circumstances where there is concerns about the principles, the viability. It's also important to note that a breach of award is a civil penalty provision to which the privilege against exposure to penalty also applies to individual accessories. In this area, there have been 2 competing lines of authorities about what a person needs to know in order to be accessorially liable for wage underpayments. So broadly speaking, the positions were, firstly, that for a person to be accessorially liable under that provision of the Act, they have to at least know of the existence of a modern award and its application to the employee who'd been underpaid. The other school of thought was that they did not need to know of the existence of the award, which really, in cases, of course, turned on this because in many instances, directors or accountants don't have an intimate knowledge of the modern award system, but have nonetheless not paid their employees correctly. And considered in light of productivity partners, the real issue in these cases then is to be determined is whether knowledge of the existence of a modern award and its application to the underpaid employee is an essential matter or essential fact of the principal's contravention of Section 45 of that Act. It's my view, and it's my view that it isn't. But I'll briefly run through the elements that need to be proven so you can see my reasoning and see how the principles in this case can apply. The elements, in short, that need to be proven to establish a breach of Section 45 are that an employer or an employee are covered by that award, that a classification schedule applies to that person, and that an employee worked a span of hours that enlivened a particular rate under that award, and that the employee was not paid that rate. It could be argued, as I've mentioned, that the emphasis across all of the sets of reasons delivered in Productivity Partners was that Mr. Wills himself did not need to appreciate or understand that the conduct of the college itself was against conscience or would ultimately be found to be unconscionable in contravention of the Australian consumer law. The knowledge that was required to render him accessorially liable was simply knowledge of the removal of the system's measures and its likely effect on students. And so by analogy, an accessory to a wage underpayment would need to know that the employer simply conducted a business in a particular industry, that an employee worked a particular set of duties, and that they worked a particular span of hours and was paid a particular rate. But, and on my view of reading this case, they would not need to know, for example, that they were covered by a particular award, that they had a particular set of duties that had the effect that that employee would fall within a particular span, what that person's span of works was at law, and what that particular employee's rate of pay at law was below the rate prescribed in the award, which is obviously a much higher bar. The first list, I suppose, that I've run through comprises what I think are the essential matters that constitute the contravention of Section 45 of the Fair Work Act, namely the facts, circumstances or states of mind set out by Chief Justice Gageler and Justice Jago. And the latter list reflects the character, quality, nature or status of those matters that is subject of the characterisation exercise required by the Modern Award and the Fair Work Act. To use a practical example, an underpayment of a casually employed grape picker under the Horticultural Award, in that case, all that might need to be demonstrated would be to make someone accessorially liable for a contravention of Section 45 of the Fair Work Act would be that the employer employed the worker to work to pick grapes, that they did so on an ad hoc basis, and that they were paid a particular rate. They would not need to know that the employer and the employee were covered by the award. They were classified at level 1 of that award or paid, for example, $21.50, which is below the prescribed rate, to be made liable. For employees, this lowers the hurdle, in my view, for what needs to be demonstrated to prove liability for accessories by a significant margin. For employers, coupled with the rise of civil penalties that were introduced in the last few years under the Fair Work Act, I think that this signals that there needs to be quite a significant attention to compliance, not only amongst the business, but particularly in relation to managers, directors, or other office-based staff, such as accountants or auditors who might have knowledge of all of these elements, but might not be typically seen to be responsible for wage underpayments in the past. So in my view, Productivity Partners does demonstrate a significant shift in the landscape, particularly in favour of potential applicants. And I expect Eric will have something to say about this and may have particular consequences for prosecutors in the same way. So having gone through the principles and the facts at length, I'll now hand over to Eric as to his views, particularly in relation to the King and Batak.
Thanks, Grace. I have the pleasure of presenting to you tonight about the consequences of the decision Productivity Partners, its application in criminal cases. Unfortunately, given the recency, or how recent, the decision from the High Court it was delivered on the 14th of August 2024, so I haven't been able to find a clear-cut criminal case where the decision in Productivity Partners has been applied. The only case that I've found in relation to a state-based prosecution of constructive murder is the case Grace has alluded to. It's the case of the King against Batak, B-A-T-A-K, and it's number 4 on the list of authorities. But I've also provided the link to the High Court's publicly available list of submissions, replies, chronologies at 12 of the selected cases list. The decision Batak was delivered by the Court of Criminal Appeal on the 10th of May 2024. So it was delivered before the decision in Productivity Partners. As Grace has pointed out, there isn't a clear ratio in Productivity Partners, 6 separate judgments, but it's unclear to me whether or not the distinctions between the various tests propounded by each of the judgments has any real meaningful difference in practice. But what I can say is that from my reading of Productivity Partners, it seems beyond doubt that the phrase knowingly concerned, where it's used in federal legislation, seems to me to be where the decision of Productivity Partners will have most frequent and ready application, because as Justice Beach-Jones said in his reasons at paragraph 346 and footnote 358, the phrase knowingly concerned appears to be used a great deal in federal legislation, and he cites a number of Commonwealth legislation in that regard, the Australian Consumer Law, the ASIC Act, and I think he also cites the Banking Act. Now, Grace drew my attention to the Migration Act this morning as well, and Section 486ZD, Roman 1, sub D, also provides that a person must not in any way, directly or indirectly, be knowingly concerned in or a party to a contravention of a civil penalty provision as defined in the Migration Act. And the most common ones that I've seen involve where people have provided immigration advice without being qualified to do so or registered with OMARA, or they've accepted fees for providing immigration assistance. Now, just very briefly, by way of my background, I tend to prosecute or defend a lot of criminal offences at the Commonwealth level, so federal offences under the Criminal Code or Crimes Act 1914. Now, the Criminal Code at the Commonwealth level, actually provides for extensions of criminal responsibility in Part 2.4 of Chapter 2. Now, if you read through the extensions of criminal liability, you'll see that the code sets out complicity and common purpose. That is very familiar, you would be familiar with the language used in that section because it talks about aiding and abetting, counselling or procuring the commission of an offence. So that is very similar to the language used in Productivity Partners. But it goes further and it sets out other ways that you can extend criminal liability as a prosecutor, so conspiracy, attempts. But you'll notice that Part 2.4 does not embrace the same language as what's used in the ASIC Act, as what's used in the Australian Consumer Law, as what's used in the ASIC Act, as used in the Banking Act, because there is no express reference to the phrase knowingly concerned. So I think that where that phrase does appear in statute or any enabling legislation, Productivity Partners is going to have a great deal of influence. But from what I could tell, given the infancy of the decision, I was not able, as I stated, to find any Commonwealth prosecutions that relied on this case. Now, I have found the case of Batak, which Grace correctly points out is subject to a High Court appeal. Batak relied on an extension of criminal liability as found in the State Crimes Act 1900 in Part 9, which captures abettors and accessories to offences. Now, as with all prosecutions, when you're alleging an extension of criminal responsibility to, in fact, capture the conduct of a person who may not have been, if I could put it this way, captured at the scene or caught at the scene of the offending. Both Justice Beach Jones and Justice Edelman talk about the need for a close analysis of what the principal's contravention in fact consisted of, and that way drives home the very fact-based or very fact-driven nature of framing an indictment and framing that indictment or prosecution in relation to the facts of the case, which can be established beyond reasonable doubt. Now, I'm a bit unfortunate in that Grace could pose a hypothetical case involving the Fair Work Act. I can't, because the High Court is going to be hearing the Crown appeal in Batak on the 4th of April 2025, so not that far away. So I have a great privilege of giving my view and then having the High Court effectively tell me I'm wrong. So I would trust my clerk is going to edit those passages out of any replay of this video. But I also think, and consistent with what the respondent has actually argued in writing in Batak, that it's a very unusual case in that the way the case was framed against the respondent involved a further step removed from ordinary murder, because the Crown alleged that the deceased in this case, had suffered an injury, being shot in the head, as part of an enterprise which involved an armed robbery, and where that armed robbery did not involve contemplation in any way that a person would be murdered. So it was effectively a constructive murder case run against the principal, but an accessorial liability case for constructive murder run against Mr. Batak. Mr. Batak was the supplier, or had supplied, a loaded Glock pistol as well as a high-vis shirt to one of the intruders of a effectively armed robbery, where they knew that the armed robbery would result in I'll use the phrase drug den, where they knew that the house which was being robbed had drugs and also had copious amounts of money, presumably as a result of the drug dealing. Now, just going a step back, just want to emphasise constructive murder. It's a very unusual concept at law, because it's one of those doctrines which imposes liability where the consequences of the conduct are not readily or intended to be foreseen by the offender. So constructive murder applies where a person undertakes or attempts to undertake a sufficiently serious crime. In this case, it was an attempted robbery using a dangerous weapon, and a person is killed in connection with doing so. And the law says that, well, the person who has undertaken that crime should be held responsible for the death of the victim. In effect, as summarised in Batak, the effect of that offence of constructive murder is to impose liability on the principal where the infliction of death or grievous bodily harm was not intended or foreseen. I say constructive murder falls into a special category because the state of mind of the principal offender that is necessary to establish constructive murder does not require that the act causing death be accompanied by intention to kill, intention to inflict grievous bodily harm, or a reckless indifference to life. Now, it also is important at this stage to distinguish accessorial liability and joint criminal enterprise, because that was the subject of some debate in the Court of Criminal Appeal, and also it will be the subject of some debate, I think, in the High Court. The key distinction between accessorial liability and joint criminal enterprise and extended joint criminal enterprise is that the idea of joint criminal enterprise embraces an agreement between the alleged offenders, whereas accessorial liability does not. joint criminal enterprise comes into play in its extended form, where the alleged offenders have effectively reached an agreement, but the carrying out of that agreement involved the commission of an incidental crime that the parties did not bargain for or did not agree on. And that gives rise to the idea of, or doctrine of, extended joint criminal enterprise, which the High Court has recently affirmed, well, not recently, in 2016, I think, in the case of Miller against the Queen. So they are different in substance, and the High Court has emphasised that they are independent of one another. And with that, by way of background, just want to run through the quick facts of the case of Batak. And you can see why the Crown chose to run its case in the way it did before the jury. Mr. Batak had supplied that loaded Glock and also a high-vis shirt to a person which, on the Crown case, he knew was going to be conducting a home invasion for the purpose of robbing the inhabitants or the residents of that property of drugs and money. Now, the high-vis, somebody pointed out to me, seems to be a bit of a non sequitur in that it doesn't seem highly relevant to the Crown's case, but I, by oversight, neglected to tell my friend that the two intruders, so there were two intruders, but one of the intruders was masked. So the intruders were masked and both were wearing dark clothing. So for some reason, the person Mr. Batak supplied the high-vis shirt to wore that high-vis shirt as part of that home invasion. So it helped the Crown, well, sorry, I shouldn't say helped the Crown, but it was part of the Crown case that the high-vis shirt that was worn by one of the intruders was the same high-vis shirt which was supplied to them by Mr. Batak earlier that evening. So during the home invasion, which happened about 3 or 4 hours after receiving the gun was fired by one of the intruders from the hallway into a bedroom. As a consequence of that, the victim suffered a gunshot injury to his forehead or head, and he passed away later in hospital. Mr. Batak was alleged to be the person who supplied the gun, the Glock, that occasioned, when fired, the injury to the deceased. And it was Mr. Batak's case at trial that either one, it was not the same gun which he had supplied earlier that evening, or in the alternative, should the jury have found that it was the same gun, that there was no evidence that he had been told by one of the intruders that it was going to be used as part of this armed robbery. Now, Mr. Batak was charged with 2 offences. He was charged with murder, contrary to Section 18 of the Crimes Act, and also with attempted robbery with a dangerous weapon, contrary to Section 97, subsection 2 of the Crimes Act. At trial, the Crown argued that Mr. Batak was an accessory before the fact, that is, pursuant to Section 346 of the Crimes Act, where the offence alleged was constructive murder, but the foundational offence, that is for the constructive murder itself, was the commission of the attempted robbery using a dangerous weapon. In short, the Crown put its case to the jury as Mr. Batak having intentionally encouraged or assisted the commission of the foundational offence of armed robbery by providing the gun and the high-vis shirt, knowing that it would be used for such an offence, and contemplating, so here's the constructive murder aspect, and contemplating the possibility that the gun would be discharged in the commission of the robbery, resulting in grievous bodily harm or death to the victim. Now, he was convicted of both offences at trial before a very experienced trial criminal judge, Justice Hume, and the trial judge had directed the jury that a verdict of guilty could only be returned on count 1, that is the constructive murder charge for which Mr. Batak was an accessory before the fact, if they found that the discharge of the gun during the attempted armed robbery with a dangerous weapon was a possibility which Mr. Batak was aware of when he provided the assistance to the intruder. Now, on appeal, Mr. Batak contended that it was an error of law to permit constructive murder to be left to the jury on the basis of Section 346, on the basis that it was an accessory before the fact. Now, I can tell you the result. The result was that ground one was upheld by the Court of Criminal Appeal because the Court of Criminal Appeal agreed that the doctrine of constructive murder could not be reconciled with a party being an accessory before the fact to constructive murder. And the Court of Criminal Appeal reasoned that based on the fundamental principles tending the doctrine of constructive murder, where the Crown does not need to establish or prove that an accused foresaw the possibility of the act or omission causing death, but as explained in Productivity Partners based on a case called Giorgiani, so number 8, but that could not be reconciled with the idea that an accessory before the fact required the Crown to establish that the accessory knew all the essential facts which made what was done a crime, and also intentionally aiding, abetting, counselling, procuring those acts of the principle that accessory before the fact would not be available to an offence of constructive murder, because an essential fact for constructive murder embraces an act or omission causing death. And the way the Court of Criminal Appeal explained this idea that death was in fact essential to constructive murder is summarised at, I think, paragraph 181 of the court's judgment, where it was held, contrary to the submissions of the Crown, that that for constructive murder, quote, death is not merely a consequence, let alone a natural and probable consequence of the foundational offence. It is the result of an act or omission causing death, where that is not necessarily inherent in the foundational offence. Foundational offence here being armed robbery. So the Court of Criminal Appeal acknowledged that armed robbery in and of itself does not include as an essential ingredient proof that a death occurred. Makes sense? But constructive murder does. And that is how the Court of Criminal Appeal reasoned, or to get to its conclusion, that this was anathema to the idea that constructive murder could apply, because as previously stated, constructive murder does not require a party or the principal, to know that the act or omission would cause death or would cause grievous bodily harm to the victim. So in that sense, the Court of Criminal Appeal found, and this is at paragraph 183, and it's at page 363 of the reported decision, that inconsistency meant that the requirement of foresight, this was necessarily inconsistent because the requirement of foresight of the act causing death was inconsistent with the notion of constructive murder. To require foresight of the act causing death is inconsistent with that notion. And the very point of constructive murder was that there is no need to establish intent or recklessness as to the death or grievous bodily harm of the victim. If a party does in fact evince that intention, or has, for example, come to an agreement with the person who he has supplied with, or who he has supplied with the gun, as in this case, it would be open to prosecute that person through an alternative strand, if you will, of murder, that is using the extension of criminal liability I discussed earlier, joint criminal enterprise or extended joint criminal enterprise. Now, the Judicial Commission has published a revised version of the suggested direction, where an accessory before the fact is relied on by the Crown to extend liability to 2/710 of the Criminal Trials Bench Book. But having now read, or having the benefit of reading the parties' written submissions in the High Court, I've actually come to the view, consistent with the respondent's view, that I think the decision of productivity partners does not really have a great deal of work to do, at least in the case of Batak, even though it's cited by both parties. I also don't think that the decision in Batak, sorry to rain on Grace's parade with the introduction, but I don't think it goes beyond the very narrow set of factual circumstances in Batak, because really I think the Court of Criminal Appeal was confined because the very unique factual scenario in Batak meant that you were always going to be dealing with a step removed from actual murder by the principal, because the principal in this case was only alleged to have been aware that, contemplated that they would commit the armed robbery, did not necessarily foresee the consequences of firing the gun, just down a hallway, firing into a bedroom. And because constructive murder is already a step removed from murder simpliciter, the extension of criminal liability that was relied on by the Crown in this case seems to me to be, in my view at least, irreconcilable with the idea of a party being an accessory before the fact. The Crown seems to try to get around this by saying, and this is what the State Crown has argued in writing, that the essential fact required to be shown in constructive murder, where an accessory before the fact is relied on, is not knowledge of the act or omission causing death, that is the firing of the gun, but rather knowledge of the act or omission which could, this is my emphasis now, if the occasion arose, such as resistance by the occupants of the property, cause death. Now, in my mind, that adds an additional hurdle, or the path, or at least I think it adds an artificiality to the approach that the court has provided in various cases involving constructive murder, because the very point, as the Court of Criminal Appeal said, is that you don't actually need to know that the result of the act, that is in this case the armed robbery, would produce a victim, for want of a better phrase, who would suffer from a grievous injury, amounting to grievous bodily harm, or would die as a result of that act. And the way that it has been put by the Crown, in that you don't need to know as an accessory before the fact that death will result, to me seems to be in tension with that idea. And this idea that there needs to be an event of resistance by the occupants leading to other inferences, to me seems quite removed, quite fundamentally divorced from the idea of constructive murder. And in that regard, I actually, if I was a betting man, I'd put money on the respondent here, because the way that Mr. Batak has framed his argument, I think, is perhaps correct. Mr. Batak has argued, consistent with what the Court of Criminal Appeal has found, is that the Court of Criminal Appeal that an accessory before the fact to constructive murder necessarily requires that the accessory have knowledge of all the facts, essential facts, including knowledge of a distinct essential fact, namely knowledge that the principal intended to do the act causing death. He argues that if you were to require this idea that there was some sort of discussion or communication of the essential fact of death possibly being an outcome, or the possibility of there being an injury amounting to grievous bodily harm, that would mean that you would effectively be in the category of joint criminal enterprise for the commission of the offence of murder, and you would not fall within the category of constructive murder. So that argument found a lot of traction with the Court of Criminal Appeal. The Court of Criminal Appeal, in fact, said that there was a strong case available to the Crown to argue joint criminal enterprise. The Crown had, in fact, abandoned that at trial, and it remains to be seen whether or not there will be a retry if the Crown seeks to pursue that course. I should note that there is a notice of contention that has been put on by the respondent seeking to quash the conviction, but also to enter a verdict of acquittal. The Court of Criminal Appeal decided not to enter a verdict of acquittal. So I think there is a likelihood that this matter proceeds to a retrial. But there is that tension that I've described. And my understanding of the doctrine of joint criminal enterprise and also the applicability, the application, of an accessory before the fact is in fact consistent with my reading of the criminal code at the Commonwealth level. The Commonwealth Criminal Code actually sets out the elements of an offence, including the physical elements of an offence. And one of the physical elements, there are 3 ways of establishing a physical element. This is in 4.1 of the Criminal Code. One of the ways that the Crown can establish the physical element offence is by establishing that a party engaged in conduct, which means an act or omission to perform an act or a state of affairs. But perhaps more critically, for BATAC, a physical element of an offence may also be a result of conduct. So in BATAC, the result of conduct, as described by the Court of Criminal Appeal, was death. That is, death was an essential fact to the offence of constructive murder. I think that argument has significant force. There is no reference to the criminal code, or at least the physical element of an offence, also embracing the idea of a result, that is the result of conduct, as being a physical element. But I think that argument enjoys, I think it's very persuasive. I agree with the conclusion of the Court of Criminal Appeal. I think they got it right. But again, I trust Jackie's going to be telling me otherwise when she edits this video, because I agree that death, as put by the Court of Criminal Appeal 181 of their judgment, that death itself is a result of conduct required to prove constructive murder, because otherwise the foundational offence, which does not necessarily include the death of a person as an element or essential element or fact, as part of the foundational offence, in this case armed robbery, it seems very bizarre that the principal has a lower standard of knowledge than the accessory would. You'd effectively be asking the accessory to be, or to foresee that possibility. And I think that is a step removed. And that is why I also suggest, consistent with the respondent's argument, that it actually, or the application of productivity partners and the concept of whether a party is an accessory before the fact to a constructive murder is very limited. It seems to me that it does turn on the facts of this case, and of course all criminal cases do turn on their facts, but I just don't see how, respectfully, it goes beyond, or the decision BATAC goes beyond its beyond application to a constructive murder case. But again, the High Court may well turn around in a few days and say that I'm completely wrong about that. So don't hold me to it.
We'll have to do a sequel, Eric.
No sequel. Just cut.
Do we have any questions that we could answer for anybody about the principles and productivity partners, or anything arising out of things Eric's just discussed?
And what Grace has discussed.
Of course. Okay, if there's no questions, we're happy to wrap up. Happy end of CPD, everybody. Thank you for attending.
Should we do another one where I just run through where I think the other side got it